Hello, 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 everybody. Welcome back to another edition of the Unfiltered Tea. Happy Sunday. How's everybody doing? I hope everybody is doing well, especially since we've just lost an hour, which in the current times is, I hate it. I don't understand why we do it anymore. It drives the dog crazy, it drives me crazy. I can't figure out if I'm coming or going. And bonus, Mercury is going to be in the microwave soon. So, yeah, brace yourselves. Brace yourselves. Tonight, we are shipping back up to Boston. We are going to have a little bit of chat. Warning, I'm going to start off with the hockey stuff because we know I'm a huge hockey fan, so we're going to start with that, and then we're going to do a little bit of the TLDR of the Karen Reid trial, round one. How I got interested in the case. This is where I usually put in the disclaimer. I'm not an attorney. I am very law adjacent. But I am not an attorney or involved in the court system in any way. So this is more of an outside perspective. But I am from Maine, and I have a lot of friends down in that area in that Massachusetts area. So I have some thoughts that I'm not seeing in some of the coverage that I watch of this trial. So we're gonna hang out. We're gonna talk that. What do you have for beverage? What do you have? Buckle up, Buttercup, because this is gonna be a show. I don't know how quick I'm gonna be. We'll see. We will see. I'm gonna try and put my own self on 1.5 speed. But I get distracted easily. So first things first, I am going to go ahead and roll the intro, and then I'm going to warn you, I'm going to get up on my soapbox and I am going to rant a little bit about the current Bruins situation. And then we will talk Karen Reid and the trials and my thoughts and my frustrations with all of it. And we'll just hang out for Sunday. So that's what we're going to do. First things first, let me run the intro. I don't know if I've managed to fix the volume. Hopefully I have, but I don't know if I've managed to succeed. We'll just find out. Let's go. Hello and welcome to the Unfiltered Tea, a show where we say all the things you wish the newscasters said, unscripted and unfiltered. We talk about politics, pop culture, and courts, so pull up your soapbox, pour yourself a cuppa, and let's go. Let's go. All right. So I signed in to my socials the other day to see that the Bruins have traded, everyone except for Swayman that is doing anything for the team. All of us fans are confused. We're all mad. Not all of us are mad. I'm mad. I'm very mad. I think my own personal thoughts, Sweeney and Neely have got to go. You have a great team when you build them up. You have a terrible team when you tear them down. And I don't know what they are thinking. I don't know what is going on. They traded Marshy to the Panthers. I cannot tell you how angry I am. A number of times I think I have posted the GIF from Clue, the flames on the side of my face. Lucky for me, I have my Marshy jersey. I'm going to keep wearing it to Bruins games when I go. But you know what? I think I'm kind of over they have made me so mad this season that I have not been following the way I want to. Luckily, we still have the PWHL Fleet. If you are a Boston hockey fan and you are as upset as I am, go ahead and watch the Fleet. Let's give the ladies the numbers. Let's see them rise up because they are doing fantastic. And I'm sad. I'm really sad. I don't I thought Monty did a fantastic job bringing a team that was kind of a little shaky together. And I said all last season he Ted Lasso'd that team into being the Bruins I loved again. And it seems like this season, starting with the firing of Monty, the management of the Bruins has just been hell bent on tearing that team down. I'm not happy. I know my Bruins will be back. I know a lot of my favorite players will come back to at least retire Bruins. I understand that. Trade season is always hard. Trade deadline is always hard. But come on, guys. I don't know what you're thinking. And yeah, I'm not, I just, come on. Why? Why? All right. Hockey rant over. Hockey rant is over. Now, we're going to do the TLDR of Karen Reid trial number 1. I'm going to do the best that I can to truly keep it TLDR. If you don't know what that means, because I had to look it up at some point, too long, didn't read. So last year, this woman from Massachusetts, Karen Reid, goes on trial for second-degree murder because the prosecution seems to think that she killed her boyfriend by backing into him with her car. How did I come into this trial? I mean, it was one of those things that got caught up online, and I mean, you guys know me. What do I watch? I watch a lot of lawyers on YouTube because I'm fascinated by the court process, watching things. I discovered a lot of these folks when the Depp Heard trial was happening. And so I started watching the Karen Reid trial. And for this, there was so much that was out there heading into trial number 1. I, like most of the folks that I follow, thought, you know what? I'm just going to start. I'm going to see what the jury sees, and we'll go from there. I'll come up with a decision based on that. And in opening statements of trial number 1, the defense hit all of us with Karen Reid was framed. Well, that's a bold statement, considering that the defense doesn't have to prove anything. They just have to provide reasonable doubt. As trial number 1 went on, the prosecution brought, warning, this is going to be exaggeration, but the prosecution brought 97 witnesses in to say it was snowing, it was a blizzard, and yeah, sure, Karen Reid might have possibly said, I hit him, therefore she did it, and it's done. Looking at the evidence that was provided by the Commonwealth of Massachusetts, they did not, for me, in any way, shape, or form, prove their case beyond a reasonable doubt. They didn't even prove their case beyond they came nowhere near proving their case. They lost me at collecting blood evidence in red Solo cups and storing it in a Stop and Shop bag in the Sally Port of the police station. Then it gets worse, because if you don't know, one thing I have learned from watching all of these trials is that discovery is somewhat non-negotiable. If the prosecution, in this case the Commonwealth, has evidence about the incident, they have to turn it over to the defense. The prosecution does not get to decide if it is exculpatory or not. They don't get to make that decision. If you followed the Baldwin trial, you saw what happens when a prosecutor makes that decision. Now, this is different. It's a different jurisdiction, different court, different judge, different facts. However, there was new evidence being turned over to the defense midway through trial number 1. And bonus, it didn't stop. There is still new evidence being turned over to the defense. So, under normal circumstances, that's not a thing that would happen. Both sides would have unless something was magically uncovered, both sides would already have all of the evidence, but this keeps happening. And so with trial number 1, I started with, let me back up. With trial number 1, I started with the predisposition to go, yeah, I want to see what the defense has, because that would not surprise me at all. As we head into trial number 2, I am personally convinced, not everybody agrees with me, it's just, at this point, too much has gone on and not enough has been turned over in the right ways for me to feel comfortable saying that the evidence might prove that she is guilty of this. I also think that there's a whole lot of evidence that actually does lend weight to the defense's claim that she was framed. There's a whole, and backing up, there's also another case involving a whole lot of the same cops in that same area of Massachusetts that was originally ruled a suicide, and evidence has come out that it probably wasn't. And a whole lot of the same names keep coming up. So I do think that the two are connected. The judge in this case does not seem to think that they are connected. I think she's wrong. Now, when I'm watching in the chats, a whole lot of folks think that this judge is incredibly biased. I thought for trial 1, she was biased, but no, it didn't strike me as being more biased than I've seen some other judges be, right? She seemed biased, but overall fair. In the last week, that has gone out the window for me. Just out the window for me. If you are following these pre-trial motions, wow. Side note, while we are here, I have linked in the description below the attorneys who also have YouTube channels, and these are the folks that I am following this trial with. I am following this trial with them in part because the first two in that list are Emily D. Baker and lawyer Peter Tragos. I put those in first because those two are the most here is the law. Did the judge follow the law? Did the judge not follow the law? They are the most neutral in that way. Given some of the rulings that have come out, I will try to summarize, but I'm probably going to fail summary because it's so much. It is so much. The defense, hang on. Buffering in real time. Sorry. You know what? I have, this is what's happening. Squirrel moment. I had a squirrel moment. Okay. We're in pre-trial. Now here, we're heading into trial number 2. Trial number 2 is supposed to start April 1st. Well, that's when jury selection is supposed to start. Because of course it is. Because why wouldn't it start April 1st? I realize it's scheduling and it's just a day on the calendar, but come on. For this, it's just a little crazy. So we are in pretrial motions. We have added Attorney Alessi to the defense team, who is fantastic. I believe his history, I believe he does a lot of appellate law because he is, and I think that's been very helpful. And this judge seems to like him a little bit better than Attorney Alan Jackson. Now, for those of you from away, for those of you who are not in New England, I know a lot of you get super, super, super sassy, myself included, at Judge Cannone's attitude towards Alan Jackson. Now, I don't know if he was wearing a Yankees shirt or cap on the first day he walked into that courtroom or something else, but let me tell you, if you are, as we call it, from away, if you are from another state, as Alan Jackson is, whenever she says, well, we don't do it in Massachusetts that way, Mr. Jackson, there's it. We do things the way we do things, and we judge real harshly folks that are from away. So she is going to be predisposed to question everything he does and says because of that. Straight up, it's a thing. We all do it to a certain extent, even if we try not to. It's just, so that's the explanation there. Do I like it? No. Do I want it to be better? Yes. Do I think at this point, Jackson, Yannetti, Alessi have consistently proven that when they say something, they bring the receipts. When they make a mistake, they own their mistake. And the same cannot be said for the Commonwealth. Brennan has made me super mad because for trial number 2, they brought in special prosecutor, Attorney Hank Brennan. Those of us in New England knew Brennan's name from the Whitey Bulger trials. Have I done a deep dive into the Whitey Bulger trials? No, not yet. But I think I might. Let me know in the comments and everything if you want me to do a bit of a deeper dive into that, because I have a feeling that I am going to see some things that will explain to me why we are here. So the most recent the most recent oral arguments in court were the defense motion to dismiss. Now, we have had some rulings from the judge since this court date. We're going to look at some of the video. I'm going to try not to completely lose my mind while we do this because I've watched this enough. Hopefully the anger has simmered a little bit, but we will see. Now, where I am, one of the rulings that came out Friday makes me super angry because judges don't, as a rule, from everything I've seen, rule against their prior ruling, rule in an opposite direction of something they ruled on previously. So in trial number 1, we had Dr. Russell. There are videos from before that I have done on the Dr. Russell Daubert hearings. Go check those out. Dr. Russell is maybe the most expert ever to expert witness. At least from the trials that I've been watching, she's done it all. She's a doctor. She's worked in autopsy. She's done ER work. She was also a beat cop in Boston. I mean, she checks every box there is to check. And when Judge Cannone ruled that she could testify again in this trial, because of course the Commonwealth wanted another Daubert hearing, and of course they got it. In Judge Cannone's ruling, which I tried to find, if if any attorneys are watching this and can help me find these actual documents, please get in touch with me, pretty please, because I want to be able to pull up the documents, and they are next to impossible to find. And I'm not an attorney, so I don't have the things that I need to be able to get the documents. Are they public? Yes. Should I be able to access them? Yes. Are they easy to find? No. Not in any way that I have found. So if you can help me, please help me. But in her 3-page decision on Dr. Russell for this trial, she went into a whole thing about how it was a close call and she wasn't sure if Dr. Russell could really do the things she wanted to do. And yes, she would let her testify, but I'm paraphrasing. But hey, Commonwealth, here's some questions you should ask her on cross-examination because, Now, then the Commonwealth wanted to bring in their expert to also testify on the wounds on John O'Keefe's arm. He's a dog behaviorist who is a doctor with a PhD, not a medical doctor. And in Judge Cannone's prior rulings in trial and things she also mentioned with Dr. Russell before is that in order to determine injuries, you have to be a medical doctor, according to Judge Cannone, because that's how it is in Massachusetts. But apparently, you don't have to be a medical doctor anymore to testify to that because she's letting this dog behaviorist come in and testify to it, even though he's not a medical doctor, even though she said that they had to be medical doctors. So in that, for a great side-by-side of those rulings, I linked the 13-minute video that lawyer, Peter Tragos did on those rulings side by side. And here's why I did that. Because Tragos is somebody where chat gets mad at him every time I catch a live chat. Chat is always mad at him, no matter which side they're on, because they feel if he's so in the middle, everybody gets frustrated. And I appreciate that. That's one of the reasons why it's like when I'm looking at this stuff, I go to all the breakdowns. He's one of my favorites for the breakdowns of this for that reason, because he is very much like, what does the law say? Highly recommend you check out his video on the side-by-side comparison because I have my own personal feelings about it, but he's actually an attorney and can discuss the issues with it better than me. I just think it shows her bias so abundantly clear that I suspect that if things continue in this way, if it is needed, an appeal will be easier than it usually is for Karen Read to obtain. That is my thought. With that, let us take a look at a little bit of the motion to dismiss, because Judge Cannone comes in fiery at Jackson. I don't like it. I'm going to warn you. If you watch trial number 1, you probably won't like it either. And here's the other thing. For my thing, I don't care if you think she did it or didn't do it, right? That's not the question here. One of the reasons I follow stuff like this is because in a case like this, where corruption is being called out or being suggested, alleged, that's the word I was looking for. Having cameras in the courtroom allows us to see in real time rulings, decisions, arguments. We do not have to rely on newspaper headlines and that reporting. Why is this important? Because this trial could have been something nobody paid attention to, but everybody started paying attention to it. And most of the folks that I watch, we all are interested in justice. The thing that does not seem to be happening at all in this particular case is justice. And the reason that I say that is because it doesn't seem like any of the police had any interest in actually finding out what happened to John O'Keefe. I have my own personal theory. I will give you my own personal theory at the end of all of this tonight. If I remember, which I may, and I may not. But if I remember, I will give you my own personal theory on what happened to John O'Keefe, who is the deceased in this case. But it doesn't feel like anybody that should be interested in finding out what happened is actually interested in finding out what happened. And it does feel to me more like the defense would like to find out what happened, and they're not getting the answers. And at this point, I mean, we can do a deep dive of all of the things. The red Solo cups is just the tip of the iceberg. Everybody's homes were rehomed. Everybody, we find out this week that the surveillance camera at the police station also happened to just change out right at the exact time that it was needed. I mean, it's just, I admit my bias has reached the point where I am in the full, corruption. I think it's there? I do. Also, I mean, come on, guys. Boondock Saints happen in Massachusetts for a reason. Let's be real. Because for those of us up here, we go, yeah, that tracks. So, all right, oh, that was a little loud. Sorry, guys. Let me bring in, you'd think I never did this before. Share screen. Share screen. Share screen. All right, guys. Let us watch a little of this motion. We're going to see how long I last. Join me on this ride. I should make myself, I think, a little, let's make me a little smaller, shall we? All right, there we go. All right. I'm going to try real hard to keep saying Judge Canone, but if I slip and start calling her Judge Bev, yeah, it's possible. All right, Judge Bev. I'd
like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sally Port videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court a history as I've learned it.
I apologize. I jumped way ahead. This is where I want to be later, but not where I want to be right now. Yeah, that is all right. Sorry. Let me go back to
Ordinary governmental misconduct, a true and correct, to the best of my knowledge, signed and sworn to under the pains and penalties of perjury this 21st day of February 2025. So the fact, what you state as fact, that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have any access to those jurors are the court officers in the Department of Security of the trial court.
Before I continue, I need to pipe up and say this came from the defense finding out that Lieutenant Fanning I'll let Attorney Jackson explain it in a minute, but the defense found out that Lieutenant Fanning possibly had access to the jury, and everybody has said, well, he didn't say anything to the jury. He didn't have anything to do with the jury. But no one has provided evidence to prove that. And if you followed the Murdaugh trials, you know that you bring people in and you have a hearing and you ask them the questions.
In this courtroom. So I am going to ask you what your good faith basis is for that. And I'd like you to start there.
If the court recalls the discussion at sidebar, we were told for the very first time, Your Honor, about this issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court with no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that because that was the next conversation that we had. When we were told on the day of closing argument to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct by the jurors or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously recognized.
You were not, just so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported. I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who are in charge of the jury.
Your Honor, I'm getting to that. I understand that. But if you'll allow.
My frustration here is she does not ever do this to the Commonwealth. She doesn't interrupt them every 10 seconds. She doesn't. It is this. If you've been watching pretrial motions, if you watch the first trial, by the time we get to this is far more annoying than it would otherwise be, I think.
Allow me to make the argument and to indicate what as my declaration says, my good faith belief, based on reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration. There was no report. There was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember. No, that was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote.
Now, just me, I hear that title, and that sounds like they might have access to the jury. That's just me.
That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
and I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us, we were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case.
Mm-hmm.
It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
you were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was. commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time in good faith. Both Mr. Unetti and I asked the court to take evidence from Lieutenant Fanning.
I think it was Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified.
For those of you who may or may not have watched the first trial, first, I recommend you go find Trooper Proctor's testimony. I warn you, though, it'll be painful. This is the trooper who was in group chats saying some real bad things about Karen Reed, saying that the owners of the house where John O'Keefe was found had nothing to worry about because they were cops too. I mean, it's Trooper Proctor is currently on unpaid leave. So yeah, if this is his supervisor who was also in that group chat, I can see where the defense would have some questions.
Testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attending to this case, and he's the source report to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on.
I agree with Jackson. Get the evidence. Show me the receipts. This is just wild. The lack of receipts from the Commonwealth is insane. And the requirement that this judge seems to have that the defense bring all of the receipts, even ones they don't know they need, is completely wild to me. I'm going to let it go a little longer, and then we're going to take a quick look at how she starts with Attorney Brennan, where I started the first time, and we will go along in that way a little bit as well.
But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago. You already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct.
Ma'am, if he is saying he didn't know, it's going to drive me nuts in trial too. Here's the thing. I will sidebar in a minute.
On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors. Is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned He never had any direct access. He didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson.
Again, if she had even a fraction of that attitude with the Commonwealth, because Brennan last week got up there and made a whole lot of claims, and when she said, and he never corrected it, he blamed the defense for something that they never did. And he went through the whole thing, and it was not until the judge said, "Do you have the receipts?" that he went, "Oh, wait, I need to correct the record." No, he never even said, "I need to correct the record." Brennan just said, "Let me give you a clarification on the timeline." Let us skip ahead. So this is an excellent way of how she's dealing with the defense. At this point, I don't like it. I don't think they've earned it. And honestly, I've lost the thread for have they done anything wrong that wasn't just an honest mistake. I don't know anymore because the Commonwealth is so egregious with no pushback at all from this judge, in my opinion, from what I'm seeing. So let us skip ahead. There's a lot more in this. This is designed for it to be a little summary. If you want me to cover this, here's the thing. I am going to be following this case gavel to gavel on some level. So if you want my thoughts on things, if we want to just take a break from all things politics this spring, or however we want to do it, let me know in the comments and on the socials and stuff like that, how we want to do this, because I will be following this trial gavel to gavel. And if we want my take on it, I'm here. Let's do this. Let's go for it. I should make myself bigger while I'm yapping away. I'm here for it. My concern, and this is why I'm being somewhat careful, is it is at the judge's discretion as to whether or not cameras are in the courtroom. I think the cameras absolutely need to be in the courtroom for justice to properly be served. But I worry that I worry that we won't get that for the entire trial. And I do think that everybody involved in this trial needs it, because I think it's important that we are able to witness these things as they happen. I think this requires transparency at this point, especially because of the accusation of corruption. And honestly, if the Commonwealth wants to prove their innocence, I think they want cameras in the courtroom too. So yeah, that's where we're at here. All right. Let me I will lose my mind if I let that happen again. All right. Let us we find out so much information in this. And I can do a deeper dive. It's just going to be a much longer stream. And I don't usually do long streams lately. Although, if we decide to cover this, streams will be long. That's okay. We can have snacks. We can have tea. We'll just roll with it. So, let us go to Brennan. We are going to come here. We're going to start things off. Let's roll.
Now, Ms. Giannetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you. As I started with a question for the defense. So I'd like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sally Port videos, and why the dribs and drabs of the way the discovery came in.
To be fair to the judge, that is a good question. Here's how I would have liked her to ask it based on how she came at the defense. And the Sally Port video and the dribs and drabs of it coming in. I would have liked more sarcasm. If we're going to have the smoke for the defense, have the smoke for these guys, because there isn't... we shouldn't be getting more video of Karen Reid's car coming in that suddenly was just magically found. Shouldn't be happening. Okay.
It may be most helpful if I give the court a history as I've learned it about the production of video in this case.
Okay.
And it will explain in context the production of video and will help create the foundation so the court can understand, and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you to clarify some of this. So know that that's what I'm focused on.
I understand clearly. In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed.
Because chain of custody for a video like this should be the default for a police station.
That I would do that, and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sally Port area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to them that that was important. There was no motion filed by the defense.
Things I've learned from watching the amazing attorneys that I follow on YouTube, it doesn't matter if Lally didn't know. He's supposed to know. The police are supposed to turn it over. He's supposed to ask if he has everything. He shouldn't have to chase it all down. And the defense shouldn't have to ask for things in this way.
What point in time?
This is leading up to trial. At that point, there had been no request by the defense for video of the Sally Port area. What I learned is that Trooper Proctor had requested Sally Port video from the Canton Police Department. And the person who was the custodian of Canton Police Video, who would download it from the DVR, was Sergeant D. Giampetro. He made a request shortly after this event on January 29th, 2022. Sergeant D. Giampetro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video.
Trooper Proctor should have told the prosecutors. Funny how everything in this case ends up going through Trooper Proctor, who is on leave for really problematic behavior.
That video is the same video that Sergeant D. Giampetro says that he downloaded the video in 6-hour segments, and that contained the front wall blurry camera inside the Sally Port and camera in front of the police station. That remained with Trooper Proctor for some time. In June, around June of 2023, Trooper Proctor then made a second request from Sergeant D. Giampetro.
Even though we already had it?
For different cameras. He wanted cameras, camera angle of outside the Sally Port area. So when the tow truck dropped the car off, leading into the Sally Port, which is now characterized as the exterior Sallyport video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior Sallyport video, but did not provide it to the prosecutors. Both of those
So the
videos
defense
remain
never
gone.
got it for trial
When
number
Trooper
one.
Proctor was called to the federal grand jury. Essentially, he testified, was asked about video, and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury,
In case it wasn't clear, this is something that should have been turned over just as a matter of habit. From everything I have witnessed, again, not an attorney, don't know all of the rules of discovery. I am going to get, so we go on with this because, of course, they can do no wrong. That is one of the things with courts. I can do no wrong. They do all the wrong things. We can do no wrong. They do all the wrong things. Let me see if there's, I gotta scoot ahead just a little bit. All right, let's see. Let's see where we're at here.
now, again,
Do I have
trying to assert some
timestamps?
type of relevance, the defense suggests there is something in the federal materials that would show relevance, because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that
In trial number one, there were a whole lot of witnesses who had phones, who just called other phones. They never spoke to each other. It was all butt dials. There was a whole lot of butt dials and a whole lot of getting rid of phones and a whole lot of things that don't tend to pop up when everything is as it should be. I'm just putting that out there. I'm going to give this just a
testimony
little
in federal
longer.
materials, you would see
Then
there
we'll
was an
summarize.
enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert. So
Yeah,
you have to look
that.
at it in context rather than say it's an unequivocal denial and there's an aha moment. There is no aha moment.
Sir,
So
Do you have the grand jury cite? I think I might have got it from Ms. Little earlier, but the grand jury testimony of Ryan Higgins, I have it. It's just easier if you have a cite to that.
I have a tab, but I don't, perhaps Attorney
I'm sure
McLaughlin
Ms.
does.
McLaughlin can get it from.
that's the other thing is Brennan walks in and he just starts saying things and he doesn't provide the references for it ever. And usually when he's asked to provide a reference, it turns out he has to correct the record. So with that, I'm going to try and keep us to an hour tonight because this is just diving in. We've been here for a while. Are we going to do longer streams? Yeah, possibly, probably coming up, especially if we're trying to cover politics and this. So let me embiggen myself. I'm gonna leave Brennan. Brennan has a really bad habit of doing things. Oh, you know what? I'm gonna swoop. Cause then swoop, Aurora. So we are still waiting on the motion to dismiss. Honestly, here's my thoughts on that. I think the defense has a fair amount to go on with a motion to dismiss. I really do. Do I think it's going to be granted? Not a snowball's chance in hell. I don't think it's going to be granted at all. This judge isn't going to let that happen. I also think that the best option for maybe possibly actually getting answers and justice for John O'Keefe is going to be a second trial. I think the defense attorneys are paying much closer attention to what is being said online, what is being said in the news, and what people are paying attention to, and I think that's helping them. I think the Commonwealth has access to that same information. I don't think they are utilizing it in the same way. I think they are seeing that the public sentiment is leaning more favorably to acquittal of Karen Read. And I think they are getting super cranky pants about it. One of the recent motions filed by the Commonwealth involved requesting that the defense file everything under seal. And this is the first time I've been interested in courts since I was in middle school watching the O.J. Simpson trial. This is the first time I have ever heard, well, we want them to file everything under seal, but we don't have to. And having that be granted. It feels weird. If it feels weird to you, it feels weird to me too. In this particular case, I don't like it at all. And I think it adds yet more weight to the defense claim that this is a setup by corrupt cops who don't want to get caught doing something. Which leads me to my personal theory. Are we ready, Internet? Are we ready for my own personal theory on this case? What happened? Do I have any factual basis for this at all? No. Nope, I don't. I am curious to see how accurate I end up being. Based on the facts that have come out about the Sandra Birchmore case, based on what I remember of where John O'Keefe worked within the police department, here's my notion. And I might be very, very wrong here. Because again, no facts to back this up. But this is my theory. Let's throw it out to the internet and let's see if at the end of trial 2, how close I am. Let's just see how close I am. I'm curious to find out if my wacky ideas are close to reality. My thought is this. My thought is that John O'Keefe was working a case that probably exposed some of the police officers that were at that house that night. Because as things have come out in the Birchmore case, a lot of these names are in that case as well. So we have that there. I think John O'Keefe found out some information, confronted somebody about it, or confronted somebody about maybe something else, but I think he had a notion of that. And it did not go well for him that night. There was nothing presented in trial number 1 that leads me anywhere near Karen Read knocking into him with her vehicle. Nothing. There was no evidence presented that gets me there. Never mind beyond a reasonable doubt. The other thing that I will say is that one of the things I have noticed online is that usually when one side or the other is very loud and very nasty with people who disagree with them, that's usually the side that doesn't have the facts on their side. And I am well aware, doing this video, that there will be comments disagreeing with everything I have to say. I see it in the chats. I see it on the lives. If we dive in and we fully cover this case, I'm going to learn how to find mods because we're going to need them. I like facts. I like evidence. I don't think the Commonwealth did a good job at all. the one thing I can tell you beyond a reasonable doubt is that this was the worst investigation I have ever heard of, ever, regarding a death. Regarding anything, really. I have never seen anything quite so abysmal. So, was it just being inept, or was there something larger? I don't know. I don't tend to trust cops as a rule. I know there are good cops out there. I have not had that as a great experience in my personal life. I have encountered a lot of the ones that are problematic, which makes me predisposed to believe this. But my idea for how this all went down, I think words were said. I think everybody was drunk. I think boys decided to knock each other around. And I suspect insecurity and or trying to cover up something else may have happened. Are we going to find any of this out? Are we ever going to know if I'm right? Probably not. Probably not. But I think John O'Keefe's family deserves a better investigation, and I think they deserve something approaching justice, and this is nowhere near what that's shaping up to be. I still have hope that Judge Cannone will see the sentiment online and will right the ship. I do not expect that, but I have hope that it can happen. So, I am going to be following this gavel to gavel myself for my own personal interest. Let me know in the comments or on the socials if you want me to do recaps. I am going to have thoughts on this. If you're interested, if we just want to take a little break from the apocalypse that is, the outer greater world, I am going to loop this right in because I'm interested and I'm going to have thoughts. And if I don't hear anything, maybe we'll just do it anyway. I don't know. I need to check in with the state of the rest of the world. But that's where we're at. Buffering in real time. Sorry. It's daylight savings. I think we have reached the end of our evening. Thank you for joining me. Thank you for being here. If you've got questions on this, again, I am not an attorney. But I am fascinated with courts and the law and jurisdictional differences and things like that. And honestly, this case is close to home. And I have we will come back to this one way or another. If you want TLDR and for me to zoom through things pretty quick, I can try and do that. I warn you, with this particular case, sometimes that can get a little dicey. Anyway, thank you for joining me. Do all of the YouTube-y things for the algorithm. Show the algorithm if you like this. Show the algorithm you like it. If you see other things that you're like, oh my God, I need your unfiltered take on that, drop them in my DMs or in the comments. I will see them. I say this every week, we got to stick together. We got to keep going on this. April 1st, jury selection begins for this particular case. We will take a look at that. We're going to ignore hockey for the rest of the season because I can't with the Bruins. And yeah, where are we at? I need to hit all of my buttons here. Thank you. As always, be well, do good, and bark a lot. And I'll see you on the next one. Thanks for joining us for another episode of The Unfiltered Tea. Don't forget to hit that like button. If you have a story you want our unfiltered take on, go ahead and drop it in the comments, and we will see you next time.